Good morning again, everybody. Thank you for joining us, Binu and Liz. Thank you very much for joining us today. So, everything and anything you ever wanted to know about stigmas and disclosures. All right, Binu, let's go.
I don't know if it's everything,
Okay.
but it's going to be because it's a big topic.
Oh my
It's
God.
a huge topic. So I'm going to sort of focus on one particular part of that, and that might give everybody a pretty good overview of what the issue is, and it might be applicable to sort of all of the issues that might come up in this topic. So in terms of kind of thinking about this as to what I was going to prepare, I read over a few of the more recent cases that came through the courts. And it's not an issue that the courts deal with often. And the reason why the court doesn't deal with it often is you really have to have a unique case to show up in front of a judge. And typically it has to have significant damages for both parties to pursue it. Otherwise, if it's a situation where the damages are lower, parties will negotiate settlements. It won't get in front of a judge, so you won't have a situation where the court will deal with it and then give reasonings as to why the law is the way that it is. But so we had an interesting case, and it comes out of BC, and it's a case that went to trial and then was eventually appealed. So I'll give a little bit of the facts of this case, and it's Wang versus Shao. It's a 2018 BC Court of Appeal case. And the background is that this was a pretty unique property in Vancouver that was being sold. In 2009, it was sold for $6.1 million. And the issue that came up was in the process of selling this property, the seller spoke to their realtor and said, well, we have, I think, a unique situation. The situation was 2 years prior. The seller's son-in-law was murdered and on the sidewalk in front of the house. And I guess the son-in-law was involved in some type of gang activity. There was, I guess, a drive-by shooting and the murder took place. 2 years later, and we'll get into some of the circumstances that happened in that sort of between 2007 and 2009. 2 years later, the seller decides, okay, we're going to put the property on the market, and goes to the realtor and says, okay, we have this situation. There was a murder. What do I have to disclose? What should I not disclose? So the realtor then, and these are sort of important facts because the court recounts all of these facts at the trial level and at the court of appeal level. All the discussions, all the testimony between, and there was multiple realtors involved. There was a senior manager at the brokerage who was asked for advice as well, who gave testimony. So they recount all of the discussions. As a side note, very important to take notes about these things. If a client is going to disclose something like this is when you get your pen and a pad of paper and start writing down not only what they're disclosing to you, but the advice that you're giving to them. So back to the issue, the realtor then says, I'm going to talk to some of my colleagues, I'm going to talk to my senior manager, and we're going to figure out, do we have to disclose this issue? After the discussion with everyone, the senior manager basically says, you don't have to disclose this. And we'll get into sort of the reasoning why there was no need for this disclosure. What ends up happening is prior to closing, the purchaser finds out about these circumstances on their own, and then decides not to close the transaction. Lawyers send letters back and forth. Seller's lawyer saying you have to close. Purchaser's lawyer saying wasn't disclosed to us, and we're not going to close the transaction. Transaction didn't close. Seller was then forced to mitigate their damages, put the property back on the market, sold the property for $5.5 million, and then sued the purchaser for the forfeiture of the deposit and their damages. So the total claim was somewhere in the range of $700,000. So at the trial level, they focused on this idea of having this information prior, the seller having some type of obligation to know that this would bother or be an issue for a potential purchaser. And the trial judge is saying, no, you have to disclose this. If you knew that this was an issue and you had a pretty good objective understanding that there's something you needed to disclose, and recounts all the discussions that the realtor and the seller had. So you sort of, you knew it's an issue, you talked about it. The seller then says, okay, I'm not going to disclose. The trial judge says, okay, you should have disclosed. You lose your case. You're not getting your deposit. It's going to be provided to the purchaser. The Court of Appeal then says, that's completely wrong. That's a completely wrong analysis in terms of what the situation is. And it came to sort of three sort of points of law. The court's just trying to think about, is this fraud? Is this a fraudulent situation? Which the Court of Appeal says, no, it's not fraud. This is a situation where they were trying to decide whether there's disclosure or not. It was, is this a misrepresentation? So are you misrepresenting the state of the property? Or is it a situation where you have to disclose what's called a material latent defect? So if we talk about what a latent defect is, it's typically a situation where you have a physical defect that's not readily visible on a normal inspection. So something that was likely to be hidden, and it's typically it's a physical defect. And in this case, the court says it also has to be a material latent defect. So a material latent defect is a situation where it's either dangerous to the occupant to live in the property, so for the purchaser, or the property is unfit for habitation. And what the court sort of looks at, and they look at all of the circumstances, and this is where it kind of gets fact specific. They look at the circumstances of the seller. Why did they sell the property? The time period between the murder and the actual sale. They look into other circumstances in terms of there was family issues, there was issues in terms of the daughter being kicked out of a private school because of this, conflict, and them having to move. And then the seller eventually says, okay, we're going to move to another area and put the daughter in another private school. So the court looks at all of those circumstances and said, it's not, the murder was not obviously a primary issue for the seller in terms of selling the property, but otherwise, it's not a latent defect. It's not something that caused the property to be uninhabitable. But they also say the important part of this is they say that they can't, the idea of caveat emptor, buyer beware, is still primary in these situations. And if the buyer is interested in these particular issues, if they're interested in knowing whether there was a murder, a suicide, a natural death, or any other circumstances, it is up for the buyer to ask that specific question. And in this case, the buyer asked this question: why are you selling the property? In which the seller said, we're moving because my daughter is going to another school, which is further away. And that's the answer. And the purchaser in that case thought that that disclosure was incomplete. And the court said, it's not incomplete. It is a reason. And if you have a situation where a seller has to disclose all of the circumstances of their life in terms of why they're making this decision, then when do the disclosures stop? At what point do you have a situation in which you have to disclose everything? Whether a purchaser, let's say the purchaser, there's a couple selling a property, and they say this in the Court of Appeal case, a couple selling a property, and there was a separation or marital issue. Maybe a purchaser at that point would say, well, the property is, cursed. I move in with my husband and we're going to get separated as well. At what point do the disclosures of those issues stop? And they really focused on this issue of, is it a material latent defect? If it's not, which they say it's not, then it's now we're shifting the onus to the purchaser. The purchaser in this situation has to ask those questions, and the seller has to answer honestly to those questions. And when we see agreements of purchase and sale, I will say in most cases, we see them in a few. In most cases, they don't have that sort of general stigma clause that says, the seller should, is warranting that there has been no murders and so on and so forth in the property. I would say probably maybe 25% of of offers might have them. So it's really important because when a realtor is thinking about it, they often think about it from the seller's perspective. From the seller's perspective is, what do we have to disclose? Well, I think the answer basically is, unless it's this material latent defect, something that makes the property dangerous to the occupant or unfit for habitation, then you don't have to disclose it. But now we have a situation where it goes back to the purchaser's realtor. Because in this case, all the realtors are being sort of questioned and shifting blame back and forth. Everyone's being sued. So now it's a situation where we look at it and say, okay, as the buyer's agent, now you have to have a few more discussions with your client about those sensitivities that they might have. Now, if you don't have those discussions, I don't think there's any liability, but you might have an issue where a transaction closes, more information is disclosed, and you just have a purchaser who's upset and is looking for somebody to explain to them, well, why wasn't it disclosed and why wasn't the question asked? So the question is sometimes, I think, cover everything, is to basically say, okay, maybe it's a standard clause that needs to be in an agreement, not because it's a situation where there's a likelihood, but to cover everybody at the end of the day and to shift the onus back to the seller to make an actual representation in an agreement of purchase and sale that says, okay, I'm providing some type of a warranty, I'm disclosing if there's anything there. And then the purchaser and the purchaser's agent can say, okay, we asked the question. Now it's up to them to disclose. If they're not disclosing, then the onus is shifted to them. The liability is there on that side. Because in this situation, the purchaser was the ultimate loser at the end of the day. And probably had some concerns with their agent about what the questions were, especially given the fact that it's a $6 million property, and if it's a situation in which this is the stigma in this case might affect the price significantly, then it's a question that sort of needs to be asked. Clients obviously have to know that some of these stigmas are sort of subjective to them, but on an objective basis, probably something like a murder or a suicide or some type of criminal activity in the building probably is significant enough to ask about and ask for a disclosure about that. But obviously the situation is that the purchaser must ask, the seller then has to disclose, but the seller doesn't have an obligation to just disclose everything.
So in that case, the murder happened outside of the property on the sidewalk, on public property. So how much of that played a part in the case,
I think it played a difference. The court mentions the fact that it is off the property, but only to the purpose of why did the seller think that they didn't need to disclose that. So the seller was making a distinction between on the property and in front of the property. So that was part of sort of the argument that they had. But the court didn't say that that was a sort of a key factor. A key factor.
So whether it happened off property or in the property, the decision of the Court of Appeals would have probably been the same.
Yeah, because their analysis basically, is this a material latent defect? Right. That's basically it. Is this a defect that has to be disclosed because the property is not habitable or there's a danger? So the question is, if you take that analysis to another situation and you say it's a husband and wife and there's a domestic violence situation where one of them gets murdered. The question obviously is, does it fit into those categories? Is it dangerous to the occupant? A murder in a domestic violence situation is probably not going to continue on. Is it, that's fact, individual specific. Is it unfit for habitation? No. So in that situation, you have to disclose. The Court of Appeal is saying, no, you don't have to disclose unless asked.
Okay, and the next question is, so that was BC. Does a BC Court of Appeal decision become, I don't know how it works, precedent across the country?
No, but you have to think about the analysis.
Okay.
Because when you have a court case in another jurisdiction. If it's really specific to specific provincial legislation, then it's going to be basically just BC specific. But what they're doing is they're doing an analysis of all the common law cases out there, the precedents that they have in multiple jurisdictions. And you can see that, if there's that type of analysis and there's an Ontario case, they're probably going to say, okay, this is a recent case, it's a 2018 case. The analysis is there of the issues. It's probably going to have some weight to a case here. So the question is, if there's nothing here in Ontario that would say, okay, well, we are altering the common law and saying, okay, well, no, you have to provide, these types of disclosures. It's going to be the same type of analysis. And you see in the cases that they go through, multiple cases, not dealing necessarily with same issues, but basically the same points in law.
So now you're suggesting that the buyer's agent now, even if it's not disclosed, to ask those questions to the other agent?
I think the question is that sensitivities of parties are probably increasing over time. The issue obviously is that this information about sort of murders, suicides are not private information. They sometimes are disclosed all over the place through, social media, the internet. So it's really, really hard to keep that information sort of in a tight little bubble. So you have a situation where that information can be readily available, be published in the future. And the situation is that people are being more sensitive to those things, and there could be a negative impact in terms of, purchasing it and then eventually selling that property. It's probably best to ask that question. It's probably best to say, okay, I think we're going to make an offer. We're going to put this clause in. They're going to have an obligation to disclose, and now, that's going to cover us. Because if you don't, you're just opening yourself up, I think, for a client to say, okay, I've been Googling, I found out some information, and that's it. Now, if the deal closes, there's really not much for the purchaser to do. They might be upset, but they're probably not going to go very far. But if the deal doesn't close, that's when you have a situation where it's going to be very, very hard to convince a purchaser in that situation to just close the transaction. They're probably going to make a very, very bad decision about not closing, but they probably just won't. Because if they brought it up and they're probably going to someone like me and saying, how do I get out of the deal? They're just not interested in that. Some might look for, some type of price abatement or whatever, but most of them are going to say, no, they don't want to close at all.
Now, I was listing agent for a property where the buyer's agent put that standard clause about stigmas, murders. And representing and warranting that, there were a couple of other representations and warranties. So we actually did not disclose. So it wasn't that something nefarious happened in the house. But we kind of went along the lines of, we're not representing and warranting a number of things, and this is one of them. And they didn't ask a specific question. So they didn't ask, did anybody die in the house? Was there a murder? Was there a suicide? They just put this clause in there. We just stroked it out along with the other one and sent it back. We eventually reached a deal.
They didn't ask why.
And they didn't ask any questions about why we crossed out, what we crossed out. So in that scenario, from my seller's perspective, we have not misrepresented. They put a clause in front of us, which we stroked out, and that was the end of it. We reached a deal.
I think the missing part is the purchaser and their agent acting why.
Right, that's not my responsibility.
No.
Right.
No, I think the question is obviously, why did they not ask? And sometimes it's just a situation where the purchaser, it's really not that important. Their agent puts it in.
Yeah.
It's they don't really care in that situation. But if they care, they probably would have followed up.
And I do think that in that case, the agent had just a library of clauses that he puts into an agreement, and I think that was one of them.
Yeah.
And that question never came up. But in terms of what we did on our side, there was really nothing that was opening him up to any liability on my side.
No, because I don't think the answer to that is, we're striking this clause because of whatever reason.
Suicide, whatever.
Yeah, we're striking the purchaser, the purchaser asked for it, you just say the seller, is comfortable with this clause, we struck it out. Basically, it. But that could be any clause, right? So you strike it out, and then it's up for the purchaser to then decide,
Yeah.
sign back with the clause back in, and to ask those questions, or
Yeah.
accept the offer. So,
I have a clause in my agreement that basically it asks the seller, are you aware of any suicides or murders occurred on the property? It doesn't say in and around the property, it doesn't say anything about statement to the property. Is that something that should change? I've never had anybody cross it out. Or never,
Well, I think when you put a clause in there, you have to indicate to them that it has to be sort of,
acknowledged.
acknowledged.
And
And
it's just a generic housekeeping clause, and basically I want to know from my buyers whether there's been any murders or suicides on the property.
and indicating to them, or maybe clarifying to them that it's really on the property.
Yeah, it's on the property, but should I reword it to say in and around?
No, because I think you're opening that up.
Yeah, you wouldn't have a kilometer away, it could have happened in that. case,
Yeah.
so.
You don't know, it's too vague.
It's too big.
Yeah, so if you say, oh, sorry, it's
It
within
works.
the boundaries of that property.
Most of the time they just laugh and then wife says, I haven't killed my husband here yet.
Yeah,
It's just ignored. But they've acknowledged that no, that they're not aware. They may have bought the house and it may have happened 10 years before they got the house. They weren't aware of it. So basically, are you aware of any murders and suicide?
yeah, it's obviously to the best of the individual's knowledge.
Yeah.
And it's usually concerns showing their value ownership.
Yeah.
You're never gonna know everything about the property, and you're not obligated to sort of research that either,
No.
so. it's-
Years ago, I had a house with suicide, and so I put in the broker remarks, please call before preparing an offer, just to let them know. And then they called me if they were gonna, and I let them know there was a suicide, but maybe I didn't need to do, that was years ago.
Well, I mean, I guess if the situation is, what is the seller willing to disclose? So.
Yeah, they did, they had said the brother had committed suicide and they wanted to be clear on that, so yes, they were on board with that.
Yeah. Yeah, I think the discussion is, I think one of the issues, and once again, the Court of Appeal sort of outlines everything. It's what were these discussions between the seller and their agent? The agent, and it's a very interesting point in the case. The realtor basically says, I advise the client to speak to their lawyer before we decide to make a disclosure. And the seller up and down in the case and during their testimony said, they never said that to me. And the agent said, absolutely, it happened. And the Court of Appeal says, we believe the agent, we believe their testimony that they said, get independent legal advice about this disclosure. And but then once again, a point of contention. Now, even the people who are on the same side, the seller and their agent, are now in conflict with each other. Because these are points that the Court of Appeal and the trial judge are looking at and saying, okay, what's the timeline and who did what at what point? And if this is material, it could shift the blame from one party to the other. So really, really important to sort of be able to recall this. And you think about the time frame here. This is a sale in 2009, and around that time, the case gets to the Court of Appeal in 2018.
Wow.
So, and then everybody is having to present arguments, about
9 years later.
9 years later about what the discussions were on the notes. So how does anyone remember? Well, you remember because you wrote it in your notes.
Yes.
And you remember because you sent the client an email and you said, I've advised you, we're not going to make this disclosure, but I think you should get independent legal advice about whether you should or not. That's the key in this, because they're going to want to know everybody's discussions.
Can I get clarity on something? Is there a requirement to answer the question, or is it required that if you are answering the question, you're doing so honestly. So I can give you a little bit of an example. Listing agent has client discloses to them, my infant child died of SIDS. This is very a sensitive topic for us. It's not necessarily something that's going to be public information and discovered. I don't want this brought up. I don't want you to talk about this. This is personal. So you get an offer or you're asked directly by an agent, have there been any deaths in the home? Are you required to answer the question, or are you required that if you answer it, you have to do so honestly?
Can you say something along, in other words, can you say something along the lines of, you know, my client has asked that I don't answer specific questions in this?
I think if you say that you don't want to answer.
You guys.
Yeah, well, that's going. So there'd have to be a nuance there, but
Well, the
you
question
make the
is,
seller ask you that, like, this is what, I don't want you to talk about this.
well, it's the idea of, you know, the semantics on the words, right? And you might answer back and say, well, there was no unnatural deaths in the property, or something to that effect. Or nobody died in the property that, you know, other than, you know, natural causes or something. If you're getting into that, you're getting yourself into a really, really sticky situation.
Yeah.
And I think that you say to your client, you know, if they ask, I have to disclose, or I have to tell them that we're not disclosing it, it's probably going to mean that
Yeah.
they're not going to make an offer. And that's the answer to the question. But the seller can't say to the agent, you have to tailor your answer in a specific way.
Yeah.
To be able to entice the purchaser to purchase the property or obscure the issue.
100%. So what about a response, something like, I'm not able to answer that question for you. You're going to need to do your own diligence around that. If that is a concern for your.
Still a red flag.
But I'm trying to understand where because our legal obligation is to follow our sellers' lawful instructions, and if they aren't. And I guess that's the question, are they lawfully obliged to answer that question if they're asked the specific question?
I think you go back and you say to the seller who's sort of discloses to you, you know, let's have a discussion about what you want me to disclose or what not. And what my standard answer is going to be. And I'm going to stick to those words and nothing more than that.
Right.
You know, and so if the question is, you know, the seller, you know, is not, you know, prepared to disclose any of that information, it's up to you to do your due diligence, then you just stick to that. That's the answer. Because the question in that case is there's no lack of disclosure,
Right.
it's just, I'm not giving you any information. It is up for you to determine that if that's an issue or not. And maybe the purchaser just not that big a deal, you know, the purchaser, the agent asked as sort of a standard process or whatever,
Right.
and they may be there accept the answer, but at the end of the day, the purchaser then, you know, the ownerships, they got an answer back. The answer was, we're not disclosing it.
Mhm.
And then they say, well, you misrepresented. Well, that's not a misrepresentation.
Right.
And it's not a material latent defect. So if it's not fitting into those categories, then you're probably not going to be successful.
Well, and I'm fully on board with the way in which you answer or do not answer that question leads to its own sort of implications and sort of situations. So that would have to be managed. I was just sort of in a very specific instance where a seller goes, I'm not signing anything about this. I don't want to talk about this, and I don't want you talking about this.
It's a different situation than the seller's asking you to lie
Correct.
or asking you to sort of, you know, sort of like I said, obscure the facts
Yeah, right.
or deflect.
Mhm.
You know, if that's the situation, then you gotta have a talk and say, you know, we're gonna have to, we're coming up with this standard disclosure, and that's basically, I can't do anything more than that.
Yeah.
So that's sort of the, you know, the different scenarios. But if you're both on board with the same, with this situation, and the seller understands, like, I'm gonna give this standard answer.
Mhm.
Here are the ramifications for giving this standard answer.
Right.
We're gonna have a lot of interest, and then we're gonna have probably people pulling back or asking more questions.
Right.
And then the seller would say, okay, that's fine. We do get situations where the seller will say to a realtor, and I've had these situations, you lie for me. You know, and then it becomes a situation where you cannot do that. It's just, there's no way, shape or form. Or the seller is basically saying, I told my agent to say X, Y, and Z, and they didn't. That situation. Where now it's a situation where there's discussions between the realtors and then the seller goes, I didn't tell you to say any of that. You know, you should have disclosed this or not disclosed this. That's where it gets very, very tricky. Because as soon as the purchaser then steps back and says, oh, I don't want to make an offer. Now the seller is saying to their agent, well, why are we not getting any interest? Or what's the problem? What are you telling me? So you have to really, really be careful about what you're disclosing and have it where the seller knows exactly what that disclosure is and do not go beyond that scope.
That's a really great point because it was, years ago, it was common practice where if you saw the line as Kelly mentioned, please call listing agent prior to preparing offer. You anticipated what that information was going to be. But to do that as common practice without a discussion with the seller as to, do they want this disclosed? And if so, how do they want this disclosed? And I'm not talking about lying, just talking about that honest discussion about that. Because we kind of go with the assumption these things need to be disclosed without necessarily allowing the seller to make a decision if they don't, as you say, affect or material latent defect or make the property uninhabitable, right?
Yes, we had our grow house, we had listed, and the seller didn't want us to disclose it. We had discussions over and over about it. And then we did disclose, the people knew that bought it, and people coming through open house eventually knew, but a lot of the neighbors knew already. After they sold, and about 6 months later, we had dinner with them, and he said, I'm so glad we did. I'm not looking over my shoulder all the time, worried that somebody sold them or found out or whatever. And he bought it cheap because he wanted it open. So, he knew it was when he bought it. So you couldn't say I didn't know.
Right.
So,
But I mean, some sellers are in situations where they're not in control of those circumstances. Like in this situation, in the case we talked about, I mean, the seller really doesn't have anything to do with the criminal activity that happened in front of their property.
Yeah.
So they're really in a tough situation.
yeah, the fact that it didn't even happen on the property.
Yes.
In the property.
As a purchaser, what are you doing? Like, you're not.
Well, I think some were paying violence.
Actually awarded it to the purchaser, like that's.
Yeah, because I think the situation is that, at the trial level, they were looking at it and saying, is this a sort of a dangerous situation that should have been disclosed? Because the purchaser in that situation is now saying, I have a family, we're in this house, walking in front of the sidewalk, in front of the property, we don't know if someone's gonna come by and mistake us.
A house targeted for whatever reason,
I was targeted for whatever reason, and the trial judge very much focused on the subjective feelings of the purchaser. And what their sort of, like I said, their sensitivities, their concerns. And the Court of Appeal was like, no, we cannot have that. We cannot open the door to everybody's sensitivities.
Right.
Because it's just a wide, it's a wide open situation. And we have to go back to sort of the tried and true. It's the buyer's obligation to buyer beware, caveat emptor, to do the inspections that are necessary and research the property before they make an offer, before they close a transaction. It's their responsibility. We cannot shift it back to the seller in that situation unless there's those very specific, exceptions to the rule.
So then to sum it all up, basically, there's for practical business comfort, selling reasons, maybe we will or should disclose it, but from a legal perspective, the obligation to disclose is a material latent defect.
Well, it's fact specific. It is specific to those situations, but it has to fit in. So, you have to do the analysis, dangerous to the occupant, you have to really say, this is going to be a concern, or it's unfit for habitation. So assume it's not an unfit for habitation situation. What is the danger in that situation? And the court's basically saying it doesn't fit into that category. It doesn't fit into that category. There is maybe a risk, but then the shift is back to the purchaser. If you think that there's a risk or there's any of those concerns, ask those questions. So would somebody, on a subjective view, be concerned about gang activity in front of their house? Yeah, absolutely. You gotta ask.
It's kind of like going to way and stuff. You already know that your clients say, I don't like this and this, so you
That's right.
checking the houses out before.
Yeah.
And
Well, one of the arguments of the Court of Appeal, and it was a novel argument that wasn't argued at the trial level, was that an individual in the Chinese community would know for sure, if they were selling a property to somebody else in the Chinese community, that this would be a concern. And the Court of Appeal just basically said, this is a ridiculous argument. You provided no expert evidence that this would be a concern.
Yeah.
And this is not tailored towards a specific community. And you're arguing basically a cultural stereotype at this point. And so, they're basically closing the door to somebody saying, well, my community or my situation would be concerned about these particular issues. And it's like, no. We don't have to worry about that. We have to basically say the purchaser has a concern about that, and it is, let's say it's cultural, we have to ask.
Look at all the number fours in Markham, a lot of them gonna change, they want to change address if they were able to. So it wasn't always possible, but
Sorry, Monica had a question. My father passed away in a home in October, natural end of life. As the listing agent daughter, how do I go about this disclosure?
Well, the question obviously is, do you have an obligation to disclose? No. If you disclose, then you're opening up some more questions about those circumstances.
Does that satisfy you, Monica? The answer? Oh, yep, there she is. Okay, might not be working.
I think that ultimately is the key. It's, do you have an obligation to disclose? And it sounds like material latent defect, dangerous, uninhabitable. Those are your benchmarks. It doesn't necessarily answer the question of should you disclose, because you may still want to disclose because you still may have legal consequences, failure to close, all of those things. Like you could still have that conversation about whether we do or not and what impact does it have. But of course, but in terms of deciding not to, it really is a matter of, is there a legal obligation to? And it sounds like from our world, having gone through that case and had this discussion, it sounds like that obligation has really shrunk around the core of uninhabitable and dangerous.
My takeaways from this are there are two very clear must-dos on the part of a seller if they fall into either of those categories. Not should, but those are musts. Onus is big time on the buyer's agent to have the conversations, ask the questions to find out the sensitivities of your specific individual client without making any kinds of assumptions about anything. Have those up front. Ask the questions, but then back on the seller side with their agent, be proactive around how do we want to manage this? And it's one thing to get the sale, but it's getting it to closing and deciding whether or not what you're doing or how you're managing those conversations is going to get you closed, not just sold, right?
Yeah.
Because yes, you can have, the seller will have recourse, obviously, likely in that situation. But that still is yet another hurdle and for them to pursue. And so that's a whole bag of tricks. Is that a fair?
Yeah, absolutely. And it's really on the seller's situation of sort of having a holistic sort of on-board approach to this. Seller, their agent, their lawyer. Because the question obviously is that when the deal is closing in that period of time between acceptance and the transaction closing, anything can happen. Lawyers got to be on board with this. If this is a situation where you've had a discussion between the seller and the seller's agent about this issue, don't be in the dark about it. Your legal representation has to know, because a letter might come in and we need to have some thought into what the answer to that question is going to be. And to say, okay, no, this is what we believe the sort of the law is, and we expect you to close the transaction. Because then you have an answer back to the purchaser, and hopefully the purchaser, the lawyer will do a little research and figure out, okay, what are our options here? Can we, are we able to not close? Or is it a situation where we're getting into a negotiation about maybe price at that point? And then the seller doesn't have an obligation to accept it, but maybe the seller then says, okay, we'll negotiate that, but there's no obligation at that point. And everybody has to be on the same page, because once again, the lawyer at some point is going to be involved, likely, whether it's before the closing or after. And they really need to know how the strategy was determined. What did the seller say to the agent, and what were the discussions around that disclosure, and what was the disclosure? Because if it's a situation where a letter comes in and we provide it to our clients, we don't want to be in a panic situation where now everybody is, let's say, going off in left field in terms of, apportioning blame or assigning blame, and saying, oh, well, my agent told me to say this, or vice versa. So sort of a holistic strategy to that. If you know it could be an issue, you might as well make sure everybody understands that that's the case. Because it can be, in some cases, like I said, fact specific. We have the fact scenario here. There could be twists and turns in this, that, it could be a situation where, it's not gonna fall into the same fact scenario here.
Yeah, I'm just curious with how long some of the stigmas hang, because if you look at all the houses in Toronto, people died in those houses years ago, they all died, over time. So I know you're not gonna put in that nobody's ever died in it, but I mean, that's years ago. My dad, was born in that house and died, he died in the house.
But some of the standard clauses actually say,
Yeah.
to the best of your knowledge, that there's.
Oh, I understand. But if somebody asks, like, okay,
And that's,
100 years ago.
This house is 100 years old. Well, I have no idea that
and that's the reason why, in some cases, I just cross out the clause and say, we're not, we have no idea.
Well, it says.
And the best of your knowledge
Yeah,
is interpretable, right? Like I know there's a legal sort of definition of best of knowledge, I think, but.
Well, you don't want to get into a situation where the purchaser says, well, I found this information on the internet.
Yes.
You should have been able to find it as well
yeah,
about the property.
right.
So cross out the clause,
Yeah.
and away you go.
Yeah.
But, because people, like, once again, if they want out of the deal, they'll grasp at straws.
Well, I'm interested, there's a condo being built over where Lytton in Young Street in Brooks Park. And they're putting it where the old funeral home was. So I'd be curious what kind of, if they disclose anything like that in a condo building, because it's going right up over where the property was, so. Because there's religions, there's people that have whatever.
Again,
Is it dying?
I know, there are. People that, but there's people that I know that go into houses and somebody.
Yeah, but I think what Binu is saying in that case is any buyer agent
Should
that's
know.
showing those
Should know.
condos needs to have the
It's on
discussion.
the buyer.
They would want me to say, this is a concern for me.
Yeah.
Or is.
Oh,
this-
I think it's big time on the buyer. We always ask all kind of questions. I mean, it's like saying, do you want it back on the highway? Do you want to, I don't want this, I don't want that, and don't want a death in there, or a suicide, or.
Was there anybody who's joining us virtually? Did you guys have any more questions? Everybody's pretty quiet on there this morning.
They're not dressed. 'cause
No,
they- they're-
sorry.
What about situation where you can find mold in the house and you didn't disclose the fact that there was mold, or the roof leak, you had the roof fixed, the mold was never removed.
Well, like I said, that's really fact specific. Like, what did the seller do about that situation? When we talk about didn't know, it's really, what would a reasonable person in that situation, think about it?
Yeah,
So if you know that there's some type of moisture in the property, a reasonable person probably would have thought about that there could be some mold in this property, right? That's a little bit of a different situation than what we're talking about, but like I said, it's really fact specific. If it's something that the seller has no idea about, then you have a pretty simple answer to that.
I ran into another one too, a few years ago, where there was a small fire in the house. And it was repaired, but there was still wood left in there, behind that was charred. And at that particular, it was part of the roof that later leaked. And the people had to pull it apart to fix a leak, only to find out there was charred parts of the house. I don't think they could do anything about it, but it was an indication that came back to me and said, what can we do about it? And I said, fix it, you know, have that part of it fixed.
And how much later was that? Oh,
Yeah, it was probably 3 or 4 years later, they bought the house. That they never fixed it, they didn't fix it properly. They just sort of fixed it a little bit and drywalled over it. Where you go. And then it caused a leak in the roof, it caused a leak, where later on, it started to show signs of leakage in that wall. When they pulled it apart, they found the fire. There had been a fire, I was needed to disclose that there had been a fire.
Yeah, I mean, it could, depending on the damaging, I mean, it could be a latent defect, maybe not a material latent defect that gets you out of closing the transaction, but it could be a latent defect that, you know, they could sue on if there was a misrepresentation or an incomplete representation of what was going on, or some type of concealment as to the work that they have done improperly. Yeah. So, I mean, it's like I said, it's really fact specific, but there's things that they can do, but maybe not, you know, we can't not close the transaction.
Yeah, no, but they should have, these people could have been aware that there had been a fire. And prior to buying the property,
Sure.
right?
Yeah.
Made a decision at that time, they wanted to continue with the deal, but it was never disclosed to us.
Actually, I saw a deal come across my desk from another company that actually had a clause specifically saying seller represents and warrants, to the best of their knowledge, that there has never been a fire or water penetration. How broad is that? Yeah. So it's interesting what people are putting.
And go.
Yeah.
So you raised an interesting point when you were answering Ken's question there about the fire. So it's not something that they wouldn't be able to not close on. So really, there are still that whole latent defect discussion. There are still disclosures that need to be made or should be made that don't necessarily lead to not closing. It just may lead to liability.
Yeah, I mean, the question obviously is, are you misrepresenting something or are you concealing something?
is the fire, I haven't done SPS for a long time. Is the fire on that one?
And then SPA.
I don't think so.
No.
Okay, no, I was curious if they haven't done one for a while. So fire,
Yeah.
just water damage, different things, but
Sort of going back to Monica's question there, I mean, we in this industry have been told disclose, right? If you know something, put it out there and disclose it. Now, basically, you're saying that she really doesn't have this.
Because the idea of disclose in most cases is a liability shifting strategy.
Right,
Basically, tell your seller to disclose everything.
yeah,
But the question obviously is that, you know, there are negative ramifications to that the
Right.
seller will be affected by.
yeah,
So the question obviously is that you can't do that without the seller understanding the ramifications of
yeah,
this.
so, yeah, absolutely,
And so you have that discussion. You understand the ramifications. The seller says, okay, I don't think I need to disclose this, right? I've been told I'm not going to disclose. That's fine. What are the ramifications of not disclosing? Seller understands they're taking those risks.
But in this case, she's the main,
yeah.
like, I'd be scared not to disclose. Like in that situation, so.
I need to sit with this for a while, I hope you're right, not disclosing.
Mhm.
So, she's right.
Yeah.
Well,
She's sort of,
and I think that goes back to that comment that I made earlier. Here about, do you have a legal obligation to disclose? That's one question. And then, should I disclose even though I don't have a legal obligation to disclose? That's a different
it's
question.
a moral.
Yeah, it's a different.
It's a different question.
It's not just even a moral question, it's just a question of saying, okay, I don't want to have any issues later on. I don't want this to turn into a court
Yeah.
case,
Yeah,
so I'm gonna disclose.
right.
But a question obviously for the seller in the specific case that I talked about was, they are concerned, because we're talking about $6 million property. There's significant, risks that are involved. They're gonna probably cost hundreds of thousands of dollars one way or another.
Right.
So they did not want to, so they wanted to get advice and they said, okay, you know what, I do want to get the best price for this property. The murder is not the primary reason why I'm leaving this property, and the court agreed. So it's really a question of saying, okay, am I going to disclose, because that's just going to, once again, take that off the table as being even a possible issue. But the question obviously, there could be circumstances where it's going to be really, really hard to sell a property because of that. Some people will accept certain stigmas. People won't.
Right.
And I think a natural death, personally, I know people that I've talked to and seller buyers and sellers, a natural death versus a suicide or a murder are totally different, because it did happen a lot of times in the old days especially. And we had a house where the son died, natural death, palliative at home. And I think it was telling last week or whatever, but it was interesting because one of the buyers came through and she had a sixth sense, whatever house she went into. And she asked us specifically, did somebody die in the house? I felt it. So of course we had answered truthfully and said, yes, he was sick, had cancer, died naturally, and ended up buying the house. They're fine with it when they knew the reason, so.
The difficulty is, like, once again, we don't know what the client's intent is.
Exactly, and even,
Because even a natural death can
Mhm.
lead to people
oh, yes.
sort of being very, very upset about those
Mhm.
situations. And other people would say, that's life.
And my brother-in-law was renting a place where there was a murder, and he'd take you through and tell you, this guy fell here, and this guy was shot over here, and he thought it was fun.
So Binu, on your case in BC there that you highlighted for us, if the reason wasn't the daughter going to school somewhere else and us being so far away, if the reason was not that they felt danger about being there, but that they don't want to be reminded every day of coming home as to what happened to their son. And that's why, would that have changed the decision, do you think?
I
No.
don't think so. Because I think what the Court of Appeal was saying is the trial judge was focusing so much about those particular facts. About sort of, how everybody was feeling about this situation. And then the court was basically saying that it's not subjective to those circumstances. But in terms of the idea of, like, there being another reason or the length of time, it just sort of gave more of a background in this case to, the court to basically say it wasn't a primary reason. And the idea of what the disclosure was, because when they asked the question, why are you selling the property? Because the purchaser asked that question. They said, well, it's because my daughter is going to another school and it's farther away, and we bought a property in that area, which they did. They had purchased a property already, and now we're selling this property. So I think that was the idea of what was the disclosure at that point. It was a true disclosure, right? It was the truth. The purchaser wasn't happy because you have to give, they want all the whole story. They want everything.
So the purchaser's intention was that the reason they're like, is
Yeah, which is what the court accepted as being
in the trial.
an absolutely true disclosure.
Right.
That was the reason. And the Court of Appeals basically saying, okay, well, when does that stop?
Yeah, right, so the appeal shut it down.
Yeah. So do you have to keep telling them everything that happened on this property from the beginning to end?
Right.
And they give, it's an interesting case, they give these kind of like hypothetical situations, and they go, should you disclose in this? Should you disclose in that? We're just basically saying, in all these hypothetical situations, no. These could be sensitive to people, but we're not going down that road.
Well, and the calls you get from agents, why are they selling? That drives more the buyers or your open house. Say, why are they selling? None of your business.
Yeah.
But anyway, I don't see.
Because they want to move.
Yeah,
And just getting back to Monica's question, I get, Monica, how you're gonna have to kind of wrestle with that. I think the difference in that situation, I'm gonna make an assumption here that might not be correct, but if you happen to be the executor, then you are in fact the seller and can make that decision, which is completely fine to disclose that. I think in isolation though, as agents with a third-party seller, I think the key takeaway here is that's not our decision to make. It's a conversation that needs to happen with the seller, explaining both the pros and cons. So we can't just necessarily assume that whatever that situation is something that needs to be disclosed. I don't think it's our call there.
No, and once again, just be careful about what you say,
Yeah.
because the other side is gonna try to draw you out into longer conversations about this and trying to pick up more information about what's going on. You just have to be very clear and to the point. Stay within the lane,
Yeah.
because all of those extra things that you're gonna say are going to be, it could be material to, deciding a case that goes to court. So you're just very careful about trying to, once again, massage it to make things just kind of be better and easier and go away, because they just don't go away.
Bait and switch things that should be happening here, right? Did anybody have any more questions? Any of you guys joining us virtually? Anything else come up? No? All good? Anybody else?
I have a question. It doesn't really entail to this, but the question is more for Gina. I had a situation where we're selling a house and the seller's son was shot and murdered by a particular guy. The guy was in jail for murdering their son. And he was the son of a major real estate broker in Durham. And my client said, I do not want anything to do, anybody from that company showing my property or making any money off my property. And I forget how we handled it. It was 10 or 12 years ago, but I said, I can't legally stop them from showing the property, but I understand where you're coming from.
Well, the seller can choose not to sell to their client. I mean, the seller can just say, I don't want to sell to you.
Can refuse the show,
Yeah.
to you, the seller.
Yeah, so they were can you refuse a showing from a particular brokerage? And you say, I don't want that brokerage showing up.
Not on the listing.
Based on our MLS rules of cooperation, I would say, no, you can't. Would there be some different ways to manage that? Exclusive listing, I've seen exclusions of purchasers. Usually they're because sellers were having previous discussions with a seller or a potential purchaser privately. That's a loaded one.
Yeah,
Good news, I think Roz is back next week, so. We'll hear how she weighed in on that
and
first one, but.
the broker was very active selling in the broker himself was very actively selling in the particular area.
I don't think it's cut and dry, Ken, but I just speaking to what our obligations and rules are as members of, the MLS and our board rules. That is pretty clear that you can't exclude from that, but that's a little bit of a.
Yeah, my
That's a
concern
loaded
was I
one.
can say, no, you can't show the property, nobody but your particular brokers can show the property. I think what alleviated the situation is that I sold the house within 2 days and it was done and gone, but it was a situation where I said, I can't refuse the showings from a particular company. You can't say, no, you're not allowed to show this property.
That's a loaded one.
Yeah.
All right. Well, I want to thank you. Oh, John. Anyway, I just wanted to thank you, Binu, for joining us again. These sessions are always very informative and lots of takeaways from them. So thank you for your time.
Very helpful.
Yeah. It's still lost on it.
Thank you guys joining us virtually. I hope you have a great rest of your day. Take care, everybody.